Court of Tennessee is now in session. Please be seated.
Okay. All right, so good afternoon. Welcome to the afternoon docket of the Court of Criminal Appeals for today. I'm Robert Montgomery, and I'm presiding judge today from Sullivan County. To my right is Tim Easter, who is from Williamson County, and to my left is Steve Sword, who is from Knox County. And let's see, Mr. Clark, did you tell me that there was an introduction? Somebody wanted to make an introduction?
Yes, sir.
Mr. Ball, you want to come around?
Good afternoon, Your Honors. It's my pleasure today to introduce to you one of the newest members of the AG's office, Benjamin Barker. He comes to us after clerking for this honorable court. I believe two of these judges are probably pretty familiar with Mr. Barker, and he's a graduate of UT Law School, and we are absolutely thrilled to have him.
Okay, all right. Welcome. Thank you for the introduction. All right, now I'm going to, do we have any other preliminary matters?
No, Your Honor.
Okay. All right, let me call the next case, please.
Yes, sir. State of Tennessee v. Billy Anderson.
Okay. All right. Now, you're Mr. Vanaway?
Yes, I am.
Now, just so I didn't say it earlier, but if you wish to reserve any time for rebuttal, just let us know on the front end, and the clerk
Yes.
will keep up with it.
Yes, Your Honor. I'd like to reserve 5 minutes for rebuttal.
Okay. All right. You may proceed.
May it please the court, Austin Van Hoy for Mr. Billy Anderson. Mr. Anderson pled guilty on February 9, 2024 to attempted first-degree murder and second-degree murder in Washington County. At the July 10, 2024 sentencing hearing, the state introduced a November 4, 2010 Florida aggravated assault conviction to push him from range 1 to range 2. This appeal asks one question: does Florida's aggravated assault statute match Tennessee's element for element so that it can lawfully enhance the range? I believe the answer is no, because Florida criminalizes an extra prong, which is assault with intent to commit any felony that Tennessee never adopted. So I have 3 points I'd like to hit today. The first one is this.
Let me just interrupt you just for a second. Okay. Now, I understand the point that you're getting ready to argue with regard to the Florida conviction. But the state, in its reply brief, talks about the fact that there were two offenses, Tennessee convictions that occurred on the same date. One was the attempted second-degree murder, and the other one was aggravated burglary. And then they made reference to the statute that allows, even though they may have occurred within the same 24-hour period of time, that both of those can be used for purposes of enhancing something from, say, range 1 to range 2, and you can create two felony convictions to make something a range 2. And and you didn't respond to that, but in the record is a notice from the state that lists both the attempted second-degree murder and the aggravated burglary conviction and the dates. And then there is also, as I saw it, a certified copy of the convictions that were introduced at the sentencing hearing. And so my question is, without looking at the Florida conviction, could the court have also found that he was range 2 based upon those two convictions, even though they didn't occur even though they occurred in the same 24-hour period of time?
Judge, frankly, I'm unaware. I was appointed just for the appeals on this case. I believe in the transcripts, the only basis for the range 1 to range 2 was this felony conviction from November 2010. I would have to go back to the record and see exactly.
But the state in their reply brief, and I don't know if you had a chance, I mean, sometimes reply briefs you just kind of go, okay, I understand. But that was one of the things that they talked about, and I didn't know if you had a response to that or not.
I do not have a response today, unfortunately, Your Honor, and I apologize for that.
Okay, but anyway, back to your argument with regard to the Florida conviction.
Yes, Judge. So there's 3 points I'd like to make. Strict equivalency. The Florida statute's categorically broader, and the state supplied no evidence tying Mr. Anderson to Florida's deadly weapon prong. And so the governing rule is out-of-state convictions enhance range only if their elements are strictly equivalent. The state bears that burden. When the record is silent, sentencing must proceed at the lower range. This court applied the same rule, State v. Vick and State v. Brooks. So the statutory comparison, Florida 784.0211, assault with a deadly weapon without intent to kill, and assault with intent to commit any felony. Assault using, Tennessee's 3913-102 says assault using or displaying a deadly weapon. So subsection B sweeps in more assault intent plus intent to steal, to burgle, to defraud, none of which Tennessee classifies as aggravated assault. So Florida is categorically broader. Florida's pattern jury instructions treat A and B as separate elements the jury must select, confirming divisibility. So in our sentencing record, I believe there's no charging instrument, plea, or judgment identifying whether Mr. Anderson pled to subsection A or B. The trial court simply read the title and assumed equivalency. Under Vick and Brooks, silence means the court must presume the least culpable element. Here, the intent to commit a felony prong that Tennessee never criminalized. So the statute of Tennessee and of Florida at that time, statute A, looks identical. So you might ask, why doesn't that save the state? Because which subsection Mr. Anderson pled to is the state's burden to prove with Shepard-approved documents. The record contains none. Maybe doesn't bias, abuse of discretion review insulate the sentence? And I would say bias applies within the proper range. Whether the Florida conviction qualifies for any range enhancement is pure legal question reviewed de novo. So I would ask for the remedy of a simple remand for resentencing at range 1. No new trial or plea is required, and alternatively, just saying that Florida statute cannot be used, so they can do the resentencing with the issue that the state is possibly bringing up, which I'm not very clear on.
So the state used the Florida conviction to enhance both the attempted murder and the second-degree murder?
I believe that's correct, Your Honor.
It was used to enhance both to get to range 2 at 75 years?
Yes.
Okay.
Yes. So, Your Honors, the facts are the 2010 conviction plea and the 2024 Tennessee murder sentence. The undisputed law is strict equivalency. The undisputed record gap is missing the documents needed. And on that gap alone, I would say enhancement fails. So I reserve the balance unless there's any questions.
Good afternoon, Your Honors, and may it please the court. Benjamin Barker on behalf of the state. Your Honors, this court should affirm defendant's sentence because the trial court properly determined that defendant was a range 2 offender. Defendant pled guilty here to attempted first-degree murder and second-degree murder, both of which were Class A felonies. After a sentencing hearing, the trial court imposed consecutive range 2 sentences of 40 years for second-degree murder and 35 years for first-degree murder. Now, to get to range 2 at that sentencing hearing, the state had to prove that defendant had 2 to 4 prior Class A, B, or C felony convictions. The state filed an enhancement notice, as you talked about earlier, Judge Montgomery, alleging that defendant was a range 2 offender and listing several different convictions. At the sentencing hearing, the state introduced certified copies of judgments in several prior felony cases, and 3 of those are relevant here. A 2013 Tennessee conviction for attempted second-degree murder, a Class B felony, a 2013 Tennessee conviction for aggravated burglary, a Class C felony, and then the 2010 Florida conviction for aggravated assault. Now, normally, as you picked up on, Judge Montgomery, the 24-hour merger rule would operate to make the 2013 convictions one conviction for range purposes. But Tennessee Code Annotated 4035-106B4 specifically carves out aggravated burglary from the 24-hour merger rule. So the state got to range 2 even without the Florida conviction. Arguably, this court need not even reach the foreign convictions question. But moving to the foreign conviction...
I'm sorry, Mr. Parker, before you move off that, does it make a difference that all the parties in the trial agreed that the 24-hour rule did apply, even though they were wrong?
I would argue no, it does not, Your Honor. We're not advancing a new issue here. The issue of range was squarely before the trial court, and the judgments are the judgments are the judgments. They're the same judgments that they were below. I'm just suggesting an alternate grounds for affirmance. I just realize that these judgments have a legal significance that perhaps the parties below didn't appreciate. But moving to the Florida conviction, defendant argued below kind of two theories. In his sentencing memorandum, he argued that the aggravated assault should be classified as a misdemeanor because of the sentence he apparently received, and then at the hearing, he argued that it shouldn't count because the Florida statute is not identical to Tennessee's aggravated assault statute. The state compared the elements, argued that they were analogous, so it was a Class C felony. Now, in foreign convictions world, this court has recognized that there's a three-step inquiry that takes place when determining whether a foreign conviction applies. One, the trial court has to determine if the offense was cognizable in Tennessee. Two, the trial court has to determine whether the foreign offense is a named felony in Tennessee. And three, if it's not a named felony, the trial court must compare the elements of the foreign offense to the Tennessee statute at the time the foreign offense was committed to determine if the conviction is analogous to a Tennessee felony. Respectfully, the test is just not whether the elements align with but do not extend beyond the corresponding Tennessee offense. It's not strict equivalence. If the trial court reaches the elements, it has to determine whether they're analogous. Here, the trial court compared the elements, found that they were not only analogous but extremely similar. And the trial court was right. Defendant was convicted in 2010 in Florida of aggravated assault in violation of Florida statute section 784.0211A. And that's listed right here on the certified copy of the Florida judgment that was admitted at the sentencing hearing. And that statute criminalized an intentional, unlawful threat by word or act to do violence to the person of another, coupled with an apparent ability to do so, and doing some act which creates a well-founded fear in such other person that such violence is imminent, accomplished with a deadly weapon without intent to kill. Now, that the Florida statute contains an alternate mode of liability is really of no consequence here because we know, based on the judgment, which mode of liability under which defendant was convicted. And it's not the mode of liability that just prescribes aggravated assault, an assault with an intent to commit a felony. This was assault with a deadly weapon. And if those elements sounded familiar to your honors, they should. This sounds a lot like, indeed it's analogous to, intentionally or knowingly causing another to reasonably fear imminent bodily injury and doing so with a deadly weapon. That is, committing aggravated assault, a Class C felony in Tennessee in 2010. The trial court properly determined that defendant's Florida conviction constituted a Class C felony for range purposes. The trial court properly sentenced defendant as a range 2 offender. If this court has no further questions, we ask that you affirm.
Thank you. Mr. Redwood.
Your Honors, I would just reiterate, if the foreign statute is broader, covered conduct Tennessee doesn't criminalize or includes multiple subsections, the sentencing court must treat the conviction as resting on the least culpable element unless the state produces Shepard documents proving otherwise, and exclude the conviction for enhancement if that least culpable element wouldn't be a Tennessee felony of the requisite class. I'm not sure if in the trial court they introduced the correct documents to prove that this was the aggravated assault A or any facts of that. Thank you.
Thank you. All right, thank you, gentlemen. Anything else, Mr. Clerk? No, Your Honor. All right, we're then adjourned until the August session of this court. Thank you.